It is not.
Doesn't the registrar have some obligation to ensure that the method selected is both reasonable and in compliance with the statute?
Oh, absolutely, absolutely. And we also reached the same conclusion after we looked at it, that yes, 15627 means what it says. And the voter can choose a manual recount, and they can pay for it if they want to spend the time and the money. They can do an electronic vote, or they can use some combination of both. And there's a reason for this. You know, as California adopts absentee ballots as they become more and more prevalent, isn't it entirely reasonable the legislature would allow the voter requesting and paying for the recount to focus on that aspect of the election where they thought the problems occurred? And that's exactly what the legislature did. It allows voters to focus and only spend as much money as they need to so that they can get the satisfaction that, in fact, the election was conducted appropriately. Now, in this case, the trial court below made a factual finding. And that factual finding was that the registrar conducted a full, complete, and legal recount. And that substantial finding, or that factual finding, was supported by substantial evidence, and specifically the evidence, the testimony of Registrar of Voters Mel Kelly. Mr. Kelly testified that every vote counted in the initial canvass was counted in the recount. No precincts were left out of the recount. That every single ballot was accounted for. And that the election day paper ballots, absentee ballots, and via rewriting votes were all included in the recount. And Your Honor, can direct your attention to pages 123, 124 of the reporter's transcript, where Mr. Kelly specifically testifies that the recount included every vote that was included in the initial canvass. Mr. Kelly also testified that he conducted a full and thorough recount, reporter's transcript, page 134, and that he continues to stand by the certification that was submitted to the Board of Supervisors that, in fact, a full recount was performed. Mr. Kelly also testified at page 107 of the reporter's transcript that his office made sure that they had counted each and every precinct before the results of the recount were certified. So we would submit that the appellants have failed to demonstrate that the trial court's factual finding that there was a full and complete recount. They have failed to demonstrate that finding was not based on substantial evidence. There was testimony, there was declarations, the court made a specific factual finding.
I think their argument is the trial court made an error of law in its interpretation of the statute. That's what I understand. Not that the findings were supported by substantial evidence, but their argument is that there's an error of law in the interpretation of the statute.
Well, you remember,
and that's a different, it's a very different argument than when we've been focused on this morning.
I mean, to the extent to which they're saying the recount only involves the VVPAT, and if that's their interpretation, that doesn't square with 1567, which again would allow you to do a pure electronic recount if you wanted. Moreover, as Judge Brenner found, that rather complex analysis of going into what the voting system means and all that, there's no indication in any of the legislative history that that's what the legislature was even thinking about. None.
Have you taken a look at the legislative history to follow up on Justice Harrison's question?
Yes, and on that point, I don't think that appellants had it entirely correct. SB 370 both amended 1967 and enacted 19253. So the legislation actually touched on both statutes. And in that legislative history, consistently, over and over again, you can see that the discussion, the focus of the bill, was to require the VVPAT to be used on the 1% manual tally. Always with the recognition that the VVPAT was an option that was available to the voter requesting and paying for the recount, but never mandated. For the good reason the legislature doesn't want to chill the recount process, but it wants to allow voters to, again, explore and review those areas of the election where they think that problems would have occurred. I think Governor Schwarzenegger said it correct when he said that it allows, the SB 370 allows the VVPAT to be used in voter requested recounts, but requires it to be used in the 1% manual tally.